All right. Welcome, everyone. My name is Victor Flatt. I'm one of the co-faculty directors of the Environment, Energy, and Natural Resources Law Center at the University of Houston Law Center. We're glad to have you join us for another in our series of the Marie Sklodowska-Curie lectures on energy transition and law. We have a wonderful speaker today. We've had a real good series of speakers. All of those are available on our website, the recordings, and you'll be told more about that soon. We're doing this in an informal way, in a meeting system rather than a webinar system, which means you can turn your cameras on and you can post questions in the chat, which I will curate, and I may even call on you if you don't mind that, because of the fun way to do this and see other people as they participate. To begin, I'm going to turn it over to our distinguished scholar who is not quite in residence anymore, but I like to think of him as still in residence, the founder of the program, Ban Zhao, and he will tell you a little bit more about today's program in the series. Thank you.
Thank you, Victor. Thank you, Professor Flatt. Good morning, everyone, and welcome to our session with our guest speaker, Professor Dan McGraw from Vanderbilt University. So I'm Oben Zaou, and I'm going to say a few words about the program itself. Funded by the European Commission through the H2020 and Marie Curie Fellowship. And next week, our series will also feature another guest speaker, Professor Michael Vanderberg from Vanderbilt University on March 22nd. Please visit our website, www.law.uh.edu/inner-center, where you'll find the upcoming events in the series and the great lineup of our past speakers and sessions. So in due course, we will be displaying the CLE credit slides. And now I'll turn it over to you, Professor Flatt, co-director of our center.
Thank you so much. It is my pleasure. First of all, I just want to again thank Obama for putting together this extraordinary group of speakers. We've really enjoyed it. We've enjoyed these connections. We've enjoyed all of the information. And again, these recordings are available on our website. It is my pleasure now to introduce an amazing speaker, Dan McGraw. He is not only how do I put this? He not only works in the academic space, which he's done off and on for a long period of time, he also works in the practical space and has been really a part of development of international environmental law going forward. He's done a lot of work, particularly, and he was the president at one point of the Center for International Environmental Law, which has been a very important player in the development of international environmental law. So in addition, he is the professorial lecturer and the senior fellow at the Foreign Policy Institute at Johns Hopkins University School of Advanced International Studies. He teaches international environmental law and policy there at the School for International Advanced Studies, as well as human rights law and environment, and at the University of Miami School of Law. He has worked in, again, government, non-governmental organizations, intergovernmental organizations, business, academia. He's worked in the United States and he has worked abroad. He has served and does continue to serve as a consultant to the United Nations regarding environment, human rights, and investment. He also has served on the National Academies of Science committees on genetically engineered crops and on biological confinement of genetically engineered organisms. He is on the board of directors of Lightbridge Corporation and the Universal Rights Group, which is a human rights think tank based in Geneva. He is co-founder of that. He is also co-chair of Human Rights Watch's Advisory Committee on Environment and Human Rights. And again, being quite the polymath, he has also served on the advisory committee to the Law Library for Congress. There's much more to say, but I want to get to his message. So I'm going to turn the program now over to Professor McGraw. Thank you.
Well, thank you, Victor, and thank you, Aubin. It's a pleasure to be here. And I was saying to Victor earlier, it's a pleasure to be back working with him again. We go way back and have been working on similar issues for quite a while. So thank you for including me here. And I'll begin by saying happy St. Patrick's Day to everyone. It is today. The color that he's associated with is mostly green, although apparently he liked blue the most, but they're both environmental colors. What I'm going to talk about today eventually is the human right to a healthy environment. I want to start, however, with a little more basic discussion of human rights and then the environment, and then how those two have been linked. These are for people who are not mavens in either human rights or environmental protection. And I think that background helps us understand why the right to a healthy environment is important and why it was difficult to reach. So if we look, first I'm going to try to share my screen here, and we'll see if that works. Can tell me if that comes up for you all.
Not yet, but it might in just a minute. There we go. Thank you.
Okay, let me get it up. So you can see that now? All right, so thinking first about human rights, the 1948 Universal Declaration of Human Rights, that is Eleanor Roosevelt there, who headed the US delegation. This, of course, is the fundamental document of human rights, and it represented a huge change in the view of who was important in the international legal system, because all of a sudden humans had international personality and protection against their own states. If we look at a word cloud of the Universal Declaration, we don't see environment anywhere. We do see everyone and right and law and those sort of words, but no environment. And that's not surprising because, of course, there was no real environmental consciousness in 1948. So when we think later about how to link human rights and environment, we have to start with a text, and later texts tend to be the same way, that don't specifically mention the environment. I would point out there the use of the word everyone. It's not just man, it's everyone, and there's a great story behind that if anyone's interested. The first international global statement of the relationship between human rights and environment came in the 1972 Stockholm Declaration. This is the text of Principle 1. Here it says man, but it really means everyone, has the fundamental right to freedom, equality, and adequate conditions of life in an environment of a quality that permits a life of dignity and well-being. So this is a fairly straightforward statement about the relationship between human rights and environment. That was 1972, but we will see that it took a long time to really give effect to that and explain what that meant. If we turn to the environment, I want to begin with the notion of ecosystem services. This is one of the two great empirical realizations that led to the right to a healthy environment. The empirical realization is that nature provides this set of services to humans for free. We may have to do some work to take advantage of them, but they're there if we don't screw up nature. And there's a kind of litany or a categorization system that UNEP came up with that I have here on the slide. But when one thinks about what these are, it quickly becomes clear that these are very, very important. If we look at provisioning, we have fuel, fiber, food, water, those sorts of things that nature provides us, and we still make use of them to a great degree. Regulating and provisioning, another example is the pollination of plants. We simply couldn't afford to do the kind of pollination of all of the plants in the world that nature does for us. Now, of course, we augment that sometimes. In the Central Valley of California, for example, people import bees, but around the world, if you look at all the plants, it simply would not be possible for us to do that. And regulating, a good example of this is the kind of purification of water that wetlands provide. As you may know, New York spent $5 billion many years ago buying a watershed upstream, and that was a good deal because it would have cost much more and been less efficient to try to clean dirty water than to let nature do that as an initial step. Another regulating impact, of course, is the protection of the Earth from ultraviolet radiation that the ozone layer provides. Cultural services include the recreation, the spiritual, the religious kind of opportunities that nature provides. And then servicing is a more fundamental kind of service, including the soil cycle and things like that. But when you look at that whole list, you come up with the realization that nature is the infrastructure of society. That is what our society is based on. And as I say, that's an empirical realization. That's not some speculation. And a lot of people don't quite realize this yet. But if you do realize it, you realize that a lot of things depend on nature that you might not have thought of before. Now, it turns out that that infrastructure is in real trouble. And these are just some examples of recent warnings. So that pollution is causing 9 million deaths per year, that we need to do something about climate change very quickly. There's still going to be a lot of harm. There's been a 60% decline in wildlife population between those years, 1970 to 2014. And if we look in North America, for example, there are 3 billion fewer birds over that same period. That's 29% fewer birds. You may have seen that in your backyards. I'm not talking about species here. I'm just talking about the number of organisms. There are perhaps 1 million species at risk of extinction. The predictions are that there will be more plastic than fish in the oceans by 2050 if things don't change, and they may change, of course. There'll be huge movements of people internally and externally between countries. And we've seen the kind of havoc that that can cause, both to the people involved, of course, but also the people who live in the areas that the migrants move to. And these predictions are not by hacks. These are the best scientists that we have in the world. And they're, of course, it's not a new thing that people have been concerned about the environment. Aristotle complained about the degradation of soil in ancient Greece. Vitruvius, the famous Roman engineer, wrote a thesis explaining why they should not use lead in the water pipes in ancient Rome, but rather should use porcelain because of lead poisoning. These are not new in a sense. What's new is the size and the seriousness of these threats. And we have to think about them. It's said by many that we're actually in a new epoch, a new geologic era where humans and human activity are the main impacts on the environment. And I list there some of the different types of effects: climate change, loss of biodiversity, toxification of the planet, deforestation, geologic changes from human activities like damming rivers, etc. The point is that humans are now, to a large degree, calling the shots, and we're not doing it very well. There is some good news, and we have to keep remembering that. It's worth fighting for change and for improvements. Many local environmental conditions are improving. If you lived in Los Angeles in the 1960s, like I did, I lived in Hollywood then, you often couldn't go outside without terrible pain in your eyes and that sort of thing from smog. That's clearly improved. We're working on pollution in the Chesapeake Bay, et cetera, and the depletion of the ozone layer seems to be under control, and conditions there are improving. So we have made progress, and that's very important to remember that we can really make things better. Integration of human rights and environmental protection, that's another major success story, and probably the major success story of sustainable development law over the last 50 years. You can probably imagine why environmentalists wanted to integrate the two areas. It has primarily to do with two things. One is you get more substantive arguments to protect the environment if you can invoke human rights. The second is procedural. The human rights system has institutions, has institutions at the regional level and at the global level where individuals can make complaints against states. There are regional systems in Africa, in Europe, and the Americas, where an individual can come and say, look, this state is violating my human rights. There's very little like that possible for the environmental area. There are two regional treaties, the Escazú Agreement in Latin America and the Aarhus Agreement in Europe, that to some degree allow that, but not to the same degree at all. So this access to the human rights institution was a real reason that environmentalists wanted to do this integration. Human rights community, on the other hand, was not at all anxious for this, and we still see resistance. I think the main reason is the concern that it's hard enough to protect what many human rights activists consider to be the fundamental rights, the right to life, right to free speech and that sort of thing, without messing around with environmental issues. I think also there was a concern that the political opposition to environmental protection would spill over and add to opposition to human rights. In any event, it's been a difficult process, and the environmentalists, the strategy was essentially everything but the kitchen sink. And we did many things. I mean, academia professors like Dinah Shelton and others wrote things. We worked with particular governments, NGOs and think tanks. I list some of the ones there. We worked with different parts of the UN system, in particular the Human Rights Council and UNEP, and World Health Organization. The regional human rights systems that I mentioned, we engaged in litigation and hearings and reports, and each of those courts and commissions that are listed there have come out with holdings and reports that vindicate the relationship between human rights and environmental protection. We've also engaged in domestic court litigation, and we worked with the human rights committees, which accompany the treaties, the human rights treaties, and also special rapporteurs. And the special rapporteurs issue, I think, deserves special attention. A lot of this occurred in the 2000s, and we were working very hard on trying to relate human rights and climate change, for example. CL, the organization I was the head of, represented along with Earth Justice, the Inuit in a petition to the Inter-American Commission on Human Rights, which is one of those regional bodies that is listed there. And the argument was that the United States was violating the Inuits' human rights because of its inaction on climate change. Now, when this first came up, people laughed at the idea. It wasn't just the idea of litigation. It was also the idea that there was a relationship between human rights and climate change. And now it's pretty much acknowledged that there is, and that there are three aspects to it. But at that point, it was not. And a major goal of the litigation was to put a human face on climate change. The commission decided not to go ahead, but we did succeed in putting a human face on climate change. We were trying to get a special rapporteur, which is one of the kinds of institutions that the Human Rights Council creates on human rights and climate change. There was tremendous opposition from that, including from the United States, but from many, many other states. And we concluded we actually could not succeed. Even with the vote, we would not get this in the Human Rights Council. And I was working then mostly with Mark Lehman, who's the head of, and now he's the head of the Human Rights, of the Universal Rights Group. But then he was the representative of the Republic of the Maldives in Geneva. And so was very active in the Human Rights Council. And so we did a pivot and tried to get a special rapporteur on human rights and environment, a broader topic, but we thought that was the only way we could move forward. The United States, again, was very opposed, and we did not want there to be much opposition to this. That had happened with the special rapporteur on toxic substances, and the countries that opposed it worked pretty hard to make sure that that special rapporteurship did not succeed. This was at the beginning. Nowadays it is succeeding, but that was many years ago. So we weren't sure what to do about the United States, but then it turned out that the United States wanted a special rapporteur on Iran, human rights and Iran. And so Mark went to them and said, look, we can do a deal here. As you know, the Muslim countries are blocking you in that effort. And for them to do it, it takes unanimity. The Maldives can destroy that unanimity if you will support the special rapporteur on human rights and environment. And the U.S. ambassador in Geneva went back to Washington, D.C., and she did her thing. She went around the corridors and convinced people that this was a good trade-off. And so we got a special rapporteurship on human rights and environment starting in 2012. It had a different name. It was an independent expert, but it was the same idea pretty much. And then that was changed to a special rapporteurship in 2015. And the first person named to that was John Knox, and Victor and Aubin probably know John. He did a truly remarkable, spectacular job during his 6 years. Now, one thing he did was he elaborated the conceptual relationship between human rights and environmental protection. And as part of that effort, he conducted a mapping of 14 aspects of the human rights system. He essentially divided it up, the whole system, into 14 parts, looking at procedural and substantive obligations. We found law firms that did this pro bono. They did the mapping. And this was the second of the great empirical realizations, if you will, was that when they looked at these issues across that whole system, each of the 14 segments tended to deal with that issue the same way. There was remarkable consistency. And one thing that appeared, if you will, for example, is that there's a human rights obligation to do environmental impact assessments when the environmental harm can interfere with human rights. None of us knew that beforehand, including John. This was a real revelation. But again, this goes along with the realization about ecosystem services. I mean, here we had an empirical realization that you've got the great consistency across the system with respect to how certain issues are dealt with. John worked to protect environmental human rights defenders. I think I have a slide later, but it turns out that about 4 environmentalists are murdered every week around the world trying to protect the environment. We know who those people are. This isn't speculation. We know their names. We know when they were murdered. There's almost no prosecution of anyone for these murders. There are all sorts of other types of harassment that occur as well, including kidnapping children and that sort of thing. And John has worked to highlight this problem and in some specific instances to try to remedy harm or prevent harm. John also, as is typical of a special rapporteur, he went to countries and visited them, and he helped train judges, which is not so typical. He identified good practices, and then all the while he was looking at how human rights and climate change are related. So what is the state of the law then after John? And he has an excellent successor as well, David Boyd, a Canadian. It's now widely understood that human rights and the environment are interdependent, that a healthy environment is necessary for the enjoyment of a vast array of human rights. And this it comes, for example, out of the recognition of the importance of ecosystem services that I described earlier. On the other side, that the exercise of human rights is vital to the protection of the environment. So we have a reciprocity in a way, and we know that environmental harm interferes with human rights. So states must protect human rights from environmental harm. That's part of their basic duty to respect, protect, and fulfill human rights. They have procedural obligations, they have substantive obligations, and they have heightened obligations regarding vulnerable groups and individuals. I'll give a little information about what those things are in terms of procedural obligations. There's the obligation to do environmental impact assessments with respect to human rights, to make environmental information public. That's an affirmative obligation, to facilitate participation in environmental decision making. This includes rights to privacy, opinion, expression, assembly, and to provide effective remedies for environmental harms for human rights. And obviously the rights to speech and association are extremely important and have traditionally been important for environmental protection. This is some data about the environmental human rights defenders. And with respect to those, and these are procedural obligations, states must protect environmental defenders when they are subject to threats. They must refrain from placing restrictions that would hinder the performance of their work, and they have to conduct serious and effective investigations of any violations against them. And as I said earlier, that is certainly not occurring at present. In terms of substance, this is one way of thinking about it. The states must protect against foreseeable environmental harm to human rights. They must protect against harm from non-state actors, and this includes business entities. They have a discretion to strike a balance, of course, between environmental protection, social development, and economic development, but the balance cannot be unreasonable or result in unjustified, foreseeable infringement of human rights. So this is how human rights relates to that issue. States should take into account international health and environmental standards. They should not take retrogressive measures. They must not discriminate among groups, and that's true generally, of course, the anti-discrimination human rights. And they must comply with environmental standards once they are adopted. With respect to vulnerable people, there are heightened duties And exactly what those are, of course, depends on the situation. So one question is, well, what standards do human rights tribunals apply? This is a very legalistic kind of question, but if you're a judge, just do a mind game, put yourself on one of these tribunals, and I come to you and say, well, I'm subject to pollution from mercury, and it's violating my right to life or to health. And so the question is, well, what standard do you apply? Right? I mean, the human rights treaties don't have environmental standards in them. So what courts tend to do is they look first at domestic standards. If the state is not even obeying its own law or complying with its own law, then it will find a human rights violation. But if the state is applying its own law, the tribunals will go beyond that and look at international standards. And the reason for that is obvious, that a state could just lower its standards and then say, well, we're no longer violating human rights because we're complying with our own standards. And this is kind of tricky because in a lot of instances, there aren't real clear international standards. And we could talk about that if people want to do it. Here are a couple citations that describe in cases how it's done, and then the comment on that by Dinah and another one by me. John Knox also produced framework principles on human rights and the environment. They're very important. They did not include the right to a healthy environment. And this was in 2018 when he did this. The same time that he submitted these to the council directed him and his successor, David Boyd, to report to the UN General Assembly on the human right to a healthy environment. So the council was looking forward and to this right. John and David did that. They made the report, and it was a very good report, but there was still an awful lot of work. Now, one question is, well, what would this right to a healthy environment consist of? I was initially skeptical, not being very imaginative. I come from Minnesota. The environment actually is kind of dangerous up there. You can freeze to death. You can be bitten by rattlesnakes, etc. But when I represented both the Inuit in the case that I mentioned earlier and later the Maldives, it became clear that there's something to this. The Inuit situation is their entire way of life is being destroyed by climate change. The Arctic is warming about 2 times the rate of anywhere else on the planet. The Inuit rely on that climate for their entire lives. Their lives are literally in danger because the ice melts from below and they fall through and die or lose their legs when they're out hunting. They can't travel between villages as well because that travel requires them at times to build igloos to protect themselves from storms. And the snow is not conducive to building igloos anymore because of climate change. Their right to property is being violated because there's less shore ice. So buildings, there's more erosion along the shore. Buildings are literally falling into the ocean. And even more fundamentally, their structures, including their roads and their airstrips, are built on permafrost, and that is melting. It's no longer perma, and some of it's not any more frost. So their right to property, the right to culture, hunting is an extremely important part of their culture, and that's just much more dangerous now for the reasons I already said. So it was clear that something very basic was happening up there that went beyond just these individual rights that I described. The Maldives, it's a similar situation. The Maldives, it's about 1,200 islands. They're stretched out along the southwest coast of India and Sri Lanka. The high point when I represented them was 2 meters above sea level. Now they have a golf tee that is 5 meters above sea level, but they will disappear with business as usual. They've already started moving people in from the outer islands. And if you look at these two situations, it convinced me that it's not just the list of these separate rights that are at stake. It's really much more fundamental. That is the right to a healthy environment. And we represented the Maldives in drafting a declaration. It's called the Malé Declaration, and it includes a functional definition. It says the right to an environment capable of supporting human society. This goes back to ecosystem services and the full enjoyment of human rights. The council finally, I would say finally anyway, it recognized on 8th of October, 2021, this last October, the right to a healthy environment. And this changed the pantheon of human rights. There is now an environmental right. It was recognized by a vote of 43 yes, 0 people or countries being opposed, and 4 abstentions. The abstentions were important countries, China, India, Japan, and Russia. You'll notice that the United States was not did not either oppose it or abstain, and that's because President Trump had removed the United States from membership of the Council. But nevertheless, we were actively opposed. Russia and the United States were the main opposition countries, and we worked very, very hard, and it's an amazing story of how many people and institutions became involved in this to get that vote. We're going to the General Assembly this spring or early summer. The U.S. has continued to oppose this at UNEP, and in the General Assembly, we're trying to convince it to stop its opposition. We'll see if that works. It's going to pass in the General Assembly, however. 100 countries have officially endorsed the right, and many others will vote in favor of it. I don't know if anyone will oppose it actively, or not vote against it is what I should say, or they'll just abstain. But it will pass. We want it to pass with as much support as it can. Domestically, over 155 countries already have this right, either in their constitution, in a national statute, or in a treaty that they're legally bound to obey. And several US states also recognize the right, most recently New York. So it's out there. It's going to be passed in the General Assembly, I think. So what does it do? Why? Who cares about this? First, it adds substance. As I said, it's different than just the amalgamation of the separate rights. And we think it clarifies the scope of states' obligation to protect the environment. It serves as a capstone in a way. It says, okay, all these other relationships that we've been working so hard through litigation and otherwise to establish are under this kind of umbrella. Some people want it to be a cornerstone to build on other kinds of rights, including rights to nature and that sort of thing. And from a practical point of view, it's a hook. Now, if you try to get some program through UNEP, for example, you need to have some international statement that an issue is important and worth working on. This provides that. And I can provide examples of other situations where that's happened, but this will allow that to go on at the international level and also to focus resources on it. So I think from a practical point of view, it's quite important. There are some outstanding issues, as I said, what's going to happen in the General Assembly, and then some details, important details like how justiciable this right is and that sort of thing. There are questions about transboundary and extraterritorial obligations. In the environmental arena, we know that a state is internationally responsible for damage caused by activities within its territory or control, damages to the environment outside of that territory or control in another country or in territory beyond national jurisdiction. that's not the common wisdom about human rights, and so that area needs to be resolved. I think business and human rights, right now the conventional wisdom is that businesses don't have any obligations that are legally binding. They have this kind of undefined responsibilities to do something, but they're not legally binding. And then the question of rights of nature, how that relates to human rights. So there are outstanding issues that are important and which will play out in the future. So thank you. Let me stop there and take any questions.
Thank you so much. That was fantastic. Just to remind everyone that here, Obama is sharing the CLE course reporting information first, and he will share that again at the end. So a reminder that if you have questions, you can post those in the chat. And in the interim, I'm going to start with there's so much here to go through, and I'm just reminded again how fast a lot of this happened with the vote in the Human Rights Council, or it seemed fast, I guess, when you've seen it linger for so long. So when you talk about the human right to the environment, it strikes me that you are talking about the states that are bound by their treaties with respect to human rights, such as Inter-American Declaration of Human Rights, et cetera. Where do you see this relating and or becoming part of customary international law? And then second part of that, how does that relate to what I think of as customary law about the avoiding the transboundary or not causing transboundary pollution?
The first part of that, most of us think that this is not customary international law now. There's some debate about that. But as a legal matter, resolutions of the Human Rights Council or of the General Assembly are not binding international law. So if they're not customary international law, then the fact that the Human Rights Council and eventually the GA recognize these won't immediately cause them to be binding international law. And some people say, well, then why does that matter? But of course, the UN Declaration on Human Rights back in 1948 was also passed as a non-binding resolution. And now most countries acknowledge that it has become customary international law. So that kind of progress is possible, but we think it hasn't happened yet. Where there are treaty obligations, for example, in the Inter-American Instrument or in the African Charter of Human Rights and People's Rights, and what's proposed in Europe, there's a protocol on this that's being proposed. If those exist, of course, then it's binding as a matter of treaty law. Again, as I say, it doesn't mean, if it's not binding, it's still meaningful for the reasons I described earlier. In terms of the relationship to Principle 21 is what you and I are both talking about, Principle 21 of the Stockholm Declaration or Principle 2 of Rio Declaration. We'll see how that plays out. I mean, countries obviously, some of them say, well, we shouldn't be obligated for things that impacts that occur in other countries. We couldn't really control those. Some of the treaties are clear about that. The 1966 International Covenant on Civil and Political Rights is clear that there's some responsibility for activities within control in your territory or control. So that's similar. For economic, social, and cultural rights, which is the other international covenant from the same year, the committee for that treaty has suggested there are some transboundary responsibilities, and one can look to the international, the customary international law obligation to cooperate generally, including with respect to human rights, to say, well, yeah, there must be some responsibilities. You shouldn't be able to destroy human rights in another country just because it's outside your territory. So I think that will play out that way, and I think Principle 21 will inform that development.
Thank you. We have several questions, but one to start. Do you think that there should be some kind of international environmental court? And it seems to me there are some different aspects to this question. One is to replace, let's say, disputes about environmental human rights harms, or perhaps to even at someday deal with rights of nature. But what is your thought about that, I guess, sort of in the framework of our international system and the United Nations?
Well, many people think there should be an international court that deals with environment. I'm in the minority, I guess, or at least I have the other view, and that is that I'd rather have environmental issues dealt with by a court like the International Court of Justice, because you can't really, I think, separate the environment out from other parts of human behavior and human activities. It's too pervasive. If it really is the fundamental infrastructure of society, then to take it out doesn't really make sense. Now, you can argue that the World Court has not done a real great job on environmental issues, but you can also argue the opposite. In the Gabčíkova case, it held that in interpreting treaties, you actually have to include Principle 21 and the concept of sustainable development, even if the treaties do not. But they have this doctrine of intertemporal law. And so I think it's better to have it all combined. Now, the argument contrary to that is it's better to have experts that really know about the environment, that have some sense of the science, that know the values that are being protected and that sort of thing. So that's a perfectly legitimate point of view. I just don't happen to agree with it.
Thank you. We have a question here, and it sort of segues with a question I wanted to ask you as well. When we talk about the right to a healthy environment and human rights in general, you noted that there was the right, if you will, to balance social, economic, and environmental. And of course, to me, that's kind of the devil in the details. And that's particularly true when human rights law says that, you know, there are particularly vulnerable communities that you do need to particularly respect with that right. And the question says, in many developing countries, the right to a healthy environment might be difficult due to other issues like poverty and population. So that, you know, those are related together. And then the question goes further to ask, how can the technologically and economically advanced nations help out? And I would even add to that, do they or will they have an obligation to help out?
Well, let me take the latter one first, which I think is easier, although I can't get into many details. But I think all countries have an obligation to cooperate. It's stated, among other things, in Principle 7 of the Rio Declaration. And so I think countries do have an obligation to help out generally. In a situation like climate change, where some countries, including the United States, have contributed much more to the problem historically, I think there may be an additional obligation. It may be moral rather than legal, but I think there's some obligation to try to help countries that are being affected by this problem that we had a large role in causing.
Well, before you leave that part for the next part, I just want you to comment on, I mean, it's clearly obvious to those that are watching that the United States, certainly in its international negotiations around climate protocols, just continues to insist that these money transfers are not restitution, seemingly to indicate that it doesn't have that liability, even if it is in fact perhaps giving some money to aid in climate change adaptation or in technology. Is that your impression as well?
Yeah, I mean, no country likes to be liable for something under international law. And the United States is particularly allergic to that. You remember when we shot down the Iranian passenger liner over the Persian Gulf? I think that was innocent, but the fact is we killed a lot of people on that plane. And we paid compensation. No, we didn't pay compensation. Sorry. Exactly. That's the point. We paid money. But we said this is ex gratia, this is a matter of grace. We don't have to compensate the families of those people that were killed. But nevertheless, we did it. So there's and the other countries behave the same way. I think one reason the State Department, the U.S. State Department, has historically been so I don't know what the right word is, has disliked human rights so much, is they're afraid that the U.S. will be held to these standards. And it really has a traditional antipathy to human rights. And I think it's that same thing. They don't want to be held liable. Doesn't mean they're bad people or anything like that. It's their job to protect the United States internationally, and that's how they choose to do it in terms of policy. So I don't know if that quite answers your question, but certainly the United States has argued that this idea of climate justice doesn't require the U.S. to pay
Right.
any.
Well, going back to the first part of that question again, I'm sorry I got you off track. The right of human rights, but the balance between the social economic environment. How do you ensure that the poorest in these poor countries do still have that, but also preserve their ability for economic and social growth?
There's an empirical assumption there that protecting the environment is bad for economic growth. And I won't accept that. Certainly in some cases there are trade-offs. That's obvious. But over the long term, countries that destroy their environment are not going to have a good economic future. So I think that one has to start with the reflection of, well, how do we balance these things, in fact? And I'm certainly not suggesting that most countries are doing a good job on that balance. But I think we are getting a better realization that, yeah, if you cut down all your trees all of a sudden, that'll get you economic growth. That'll get you some income right away. It'll also get you erosion. It'll get you more climate change around the world, et cetera. There are all sorts of costs to that that don't appear in the immediate balance sheet. So one big issue is taking sustainable development seriously and saying we do need to balance these things, and we can do that if we use environmental and human rights impact assessment, for example, and look at the long-term consequences and then try to do things in a sensible way. We'll be better off. Now, I lived in India, as you know, for several years, and literally saw people starving to death on the streets. And I'm not trying to trivialize the decision-making difficulties involved in this sort of thing. But decision makers have to take a long-term view as well, and that involves protecting the environment, in my judgment.
We have a question from Professor Dirnbach. And I think it's an interesting tie between a lot of scientific or technology-based standards that we pioneered in the United States and we've seen around the world. But what about when either on paper, those are not actually adequate, or a plaintiff claims they're not adequate to protect protect the right to the environment or human rights, human life. And I would add on to that, what if they on paper do that, but aren't enforced in order to do that, which I think is a big problem in the US and around the world.
Well, first of all, Professor Dernbach is one of the world's experts on sustainable development, so I'm reluctant to wade into. He should probably answer the question, but it is a problem. I mean, a lot of standards are not enforced. To take the latter part of the question, and it's one reason we need an active civil society, because historically that's what's been necessary to protect the environment, including to get laws to be enforced. So I would focus on that question, partly on judicial training and that sort of thing, because I think a lot of judges haven't been educated in a way that allows them to understand the importance of some of these things. But also we need civil society that's active and effective. That's getting harder and harder with countries' control of information and communication technology, but and other kinds of harassment, like the murders of environmental human rights defenders. But we really need civil society and the news media, of course, as well, to be allowed to be active. In terms of whether the standards are strict enough, in a human rights context, as I started to say earlier, what happens is the tribunals first look to those standards, the domestic ones. And if they're not, if the country isn't supporting them, then there's a human rights violation. Not supporting, but not respecting them. If they are respecting them, then the tribunals nevertheless go on and look internationally, and they do it in ways that one can easily be skeptical about. They will invoke treaties that the country who's being challenged is not a party to. So it's a treaty whose standards the country has not agreed to. And normally one would say, well, wait, the international law is based on consent, and the country has not consented to those. And one answer to that is, well, they have consented to be bound by human rights, and there have to be some standards if human rights are going to mean anything. And so it's legitimate for a tribunal to look to these standards. Sometimes they look to standards that are not legally binding on anyone, like for example, from Codex Alimentarius. Those are by definition not legally binding, but human rights tribunals have used them to say, well, you have to meet at least this standard. And sometimes the tribunals even go to principles like those in the Rio Declaration. And I am troubled by that, I must say, because those are so general that I'm not sure they really provide the kind of principled basis for a decision. But you see that happen as well. So that's what happens, and as I say, it can be criticized. The two articles that are in the slides, and I hope people have access to those slides.
We will have those posted next to your recording after this as well.
Yeah, talk about these issues and explain them in greater detail. But it's an important question. Thank you.
Thank you so much. Our time is up, but I'm going to turn it over to Aubin because I know he is going to also end this, but also, excuse me, for the slide as well. So Aubin, I will turn it over to you. I want to thank you so much for this.
May I ask a quick question, Professor, to Professor Magro? So how could play out the option of a customary international law right, resulting from the combination of the eventual adoption of a right to a healthy environment by the General Assembly and what we currently have into state constitutions and international declarations?
Well, the principle of or the test for customary international law is what states do thinking they're required to do it, and you can ask, is that why states are doing that? Does Russia have a constitutional right to a healthy environment, which it does? Does it have that because it thinks it's required by international law? And the answer is probably no. I don't know, but I could imagine the answer would be no. But you'd have to ask that of each of the countries that have either national legislation or a constitutional provision that provides it. And then you'd have to ask, are they really the same thing? The language is often different. Some are clean, some say clean, some say healthy, some say sustainable, some say other things. So I think it's a difficult argument to make right now. I think down the line it will probably be much easier. I think you could also ask, well, is this to use the language of the statute of the International Court of Justice, is this one of those general principles of law recognized by civilized nations? And with 155 countries, you can make that argument too. But we're not trying to make that argument right now. We're trying to do this stepwise, and that's the only way we've succeeded, actually, is by very painstakingly going case by case and article by article, etc. So right now we're focused on getting it through the General Assembly with as positive a vote as possible.
Thank you.
Thanks so much. So our next speaker will be Professor Michael Vanderberg from Vanderbilt University on the environmental supply chain contracting. Over to you, Victor.
Thank you so much again, Professor McGraw. As I said, this recording and PowerPoint will be posted on our website. Thank you all for coming and for engaging, and particularly thank you, Aubin, and thank you also Professor McGraw.
Thank
we'll see you next time. Thank you. Bye-bye.
Bye-bye.